can the central government proceed contrary to the recommendation? The answer in my respectful submission is yes. The Reserve Bank of India may say that, look, we require 86% or 90% demonetization. Central board recommends it. And the central government says nothing doing. We think this is going to be too onerous, too drastic. Look at your own governors, what they have said in the past. This never works for black money abolition, etc. We need to be disclosed. They ought to be perused by the court. Why? Because it reduces and diminishes the power of judicial review. So please consider that facet as well. And I would be greatly obliged. I think the part on guardrails and to lay down defining parameters is an aspect which survives apart from individual cases like mine, where there may be 1,62,000. I believe it's an imperative. I ask myself, can Parliament, in exercise of its plenary jurisdiction as a theoretical issue, pass a law extinguishing both legal tender as well as central government guarantee? Only parliamentary statute or ordinance. My answer is yes, it can do that. All right, subject to whatever constitutional safeguards, etc. there are. No problem. 26 is concerned. I'll just state it point-wise, and then I will make the submission. My first point on section 26 is that it is complete and self-contained in terms of its operation and effect. That's my first point. It doesn't require a prop from somewhere else saying do this, do that. So it is.
It's contrary to submissions of Mr. Chidambaram.
I'm sorry?
It's contrary to submissions of Mr. Chidambaram.
I don't think it's contrary.
He says that the entire provisions of the RBI will have to be taken into consideration.
No, of course, no, sorry. So let me make it clear. That was my submission as well. So I'm making that submission as well. You have to have regard to the entire scheme of the RBI Act. I'm not saying that you don't have to have regard to the scheme of the RBI Act. My submission is in this context that 26(2) is, let me put it differently, is an administrative power. First, please note that. It's in exercise of executive functions and it is under 26(2). So I am not for a moment suggesting that you rip out 26 and don't read it with the other provisions of the RBI Act. Please read them all together. But it doesn't require a prop or a handle or some sort of action outside the executive action contemplated under 26(2) to be complete in all respects.
According to you, for interpreting section 26(2),
yes,
no other external aid is necessary.
No, that's not my point. I am arguing exactly the contrary. But now let me just restate the point. For interpreting section 26(2), I'll make myself very clear. Please have regard to the scheme of the entire Act, the Reserve Bank of India Act, and in particular, the provisions under central banking functions in Chapter 3. And we read those out to the court. We read out 20, 21, 22, 23, etc. and explained the entire scheme. So on interpretation, my submission is that with regard to interpretation of this provision, please have regard to all, the entire provisions, the preamble, and put all the provisions of the Act and read them in the context of the statutory provisions. That's on interpretation. Now I'm on the working of 26(2). I'm on the working of 26(2). So my first point is, it is an executive action alone. What is contemplated in terms of recommendation and decision by the central government is executive action. So that's the point. I'm also supplementing that point by saying, since it is self-contained in its working, not self-contained in its interpretation. Since it's self-contained in its working, it does not require a prop of legislative support or action outside the operation of the RBI Act. It doesn't require something extra or something else. So this is the next point. Now please see 26(1) and 2, and then I'll just make my further submissions. In 26(1), there are two concepts. Two distinct concepts in 26(1). The first concept is shall be legal tender. That's the concept which you will find in the marginal note, legal tender of character of notes, And in the first part of 26.1, you will find every banknote shall be legal tender. That is one legal concept or facet. The second legal concept in 26.1 is shall be guaranteed by the central government. So there's a central government guarantee that is completely different from legal tender, because legal tender is the concept of it can be exchanged for value, etc. It is backed by statute. But that the central government is going to guarantee that the sovereign assurance is a second legal concept in 26.1. So this is as far as 26.1 is concerned. Now I'll come to 26.2 and then go back to 1. On the recommendation of the central board of the central government, may by notification in the Gazette of India declare that with effect from such date as may be specified in the notification, any series of banknotes of any denomination shall cease to be legal tender, save at such office or agency of the bank, and to such extent as may be specified in the notification. So now I'm answering the question which Justice Nagaratna had raised earlier on. My submission is a recommendation by the central board is a condition precedent. That's my submission. It is a necessary requirement for the exercise of power under 26.2. If there is no recommendation, then 26.2, according to us, on an aspect of interpretation, cannot be exercised at all. So it's a precondition. If there's no recommendation, you cannot operate under this provision. That's one element. The second question asked to us was, can the central government proceed contrary to the recommendation? The answer in my respectful submission is yes. The Reserve Bank of India may say that, look, we require 86% or 90% demonetization. Central board recommends it. And the central government says nothing doing. We think this is going to be too onerous, too drastic. Look at your own governors, what they have said in the past. This never works for black money abolition, etc. We reject your recommendation. So the central government holds the trumps. It is the central government decision. The power of the Reserve Bank of India is only to recommend, but there must be a recommendation. This is the scheme. Now take a situation where, examine the situation immediately after 8th of November, 9th of November, 10th of November, right till 30th of December 2016. Now what am I focusing on? I am now focusing on the second part of 26.1. And I am focusing on this because I am seeking to explain the scheme which I don't believe has been correctly put forward by the Union of India or the RBI. On the 9th of November 2011, the question I asked myself is, was the central government guarantee alive? The answer is yes. Was it alive on the 10th of November, 11th of November, and so on till the 30th of December? The answer is yes. So the central government's guarantee under 26.1, it ceased to be legal tender, the first part. That happened immediately on 8th of November. But the central government guarantee subsisted. Now, right from 8th of November till the 31st or the 30th of December 2016, there was no question of enforcing this guarantee. No question of enforcing this guarantee. Why? Because the government had a scheme by which you could exchange for value. So the government was good to its guarantee. It was good to its guarantee because it said that, look, I have guaranteed it. You come through this scheme. Yes, initially 4,000 rupees per day. That's all right. That was just in terms of the mechanics. But my guarantee remains intact. So please recall that the guarantee remained throughout, right till the statute, which we will deal with subsequently. So that concept remained. Now, supposing there were no statute, the 2017 Act, 2016 Ordinance. If there were no statute, the guarantee would have remained.
Continued.
It would have continued. The guarantee would have continued, which would have meant, Yes.
Every bank note of a denomination other than 1 rupee
Right.
contains a promise by the RBI.
Right.
The guarantee is by the government. The guarantee is by the government.
Correct.
The promisor is the RBI.
Correct.
That is how we have to look at it. If the promisor is the RBI and the guarantor is the central government,
Yeah.
once the primary liability, you will have to go back to the Contract Act because it is also a negotiable instrument.
Right.
Therefore, the liability of the guarantor is coextensive with that of the promisor.
Yeah, I agree with you.
Therefore,
That's possible in most situations.
yes.
So we'll come to that. That's the 34 point. Your Lordship is as usual far ahead of me. I'm going a little slowly. The point I'm making now is, so I'm suggesting a situation where there was no act at all. I'm just suggesting to the court what would have happened. What would have happened is, now I'm answering your Lordship's question, that say on the 1st of January 2017 or on the 10th of January 2017, the government of India would still be liable in terms of the guarantee. And as your Lordship correctly said, the Reserve Bank of India would still be liable under 34. So you would have had a slew of writ petitions and suits by parties who could not exchange, saying that now I'm enforcing a statutory guarantee and I'm enforcing a statutory liability. In a hypothetical situation where the act did not come into force. But I am emphasizing this because there are distinct legal concepts. There is one legal concept of legal tender. There's another legal concept of central government guarantee. And there is no provision. Now we come to the next stage. There's no provision under the RBI Act itself by which you can extinguish 26(1) and you can extinguish 34. 26(1) liability of the government as a guarantor is a statutory liability. The only way that can be undone is by either another statute, or if you have some provision in the RBI Act itself by which they can by notification or otherwise negate 26(1). There is no such latter position. So the only way the government could have extinguished its liability is through a statutory provision, which is a separate whole area of operation, extinguishing the central government guarantee under 26(1). Now just go to 34. Go to 34. Now this is slightly different. It's not in conflict with what Mr. Chidambaram said, but it's a nuance, I hope.
But,
Yes, I'm sorry.
Diwan, 26(1) and 2 will have to be read together.
We'll come.
When 26(2)
Yes.
provide that it empowers the central government
Yeah.
to issue a notification
Yeah.
that from a particular date,
Correct.
any series of the banknotes
Yes.
shall cease to be a legal tender.
Correct.
So once they cease to be a legal tender,
Yeah.
then how can the guarantee
Guarantee survive.
survive?
Of course it survives. It definitely survives. Now, this is a very important question.
No.
First and foremost, I agree with the court. Sorry.
No, let us read 26(1) again.
Yes, I'll read it slowly. Subject to the provisions of subsection 2, every banknote shall be legal tender at any place in India in payment or on account for the amount expressed therein and shall be guaranteed by the central government. May I also read two?
Once it ceases to be a legal tender,
Yes.
how can the guarantee still survive?
Correct. So now that's very important. So this is a very important point. Legal tender is both between citizens to each other, because you see the concept at any place in India. So at any place in India, two citizens exchange for value is legal tender, and it's backed by the Act, etc. So to a completely private transaction which has nothing to do with the government of India, it is legal tender. Now, who backs it and supports it and what gives you value and assurance for that? The central government guarantee. So now let me just give you a very simple example. Supposing we had a handful of, 10,000 rupee notes. Your Lordship saw that in the earlier demonetisation, right? 10,000 rupee notes, barely in circulation, etc. Hardly in circulation. But for one of the reasons which Mr. Chidambaram suggested, they are old notes, they've got crumpled, etc. The government of India, it's some minute fraction of the currency in circulation. And the government of India says that, look, we are getting rid of this. No longer legal tender, right? A recommendation is made by the Reserve Bank of India in the proper order. It says that, look, there are 100 or 500 of these notes. We are not having it. So they issue, on the recommendation of the Reserve Bank of India, the Government of India issues a notification under 26(2), which is the mechanics as far as 26(1) is concerned. Now the question put to me is, it ceased to be legal tender. Doesn't the guarantee automatically disappear? That's your Lordship's question. My respectful submission is no. In the hypothetical situation which I've given you, the central government or parliament may say, or the government will say, we don't need to extinguish central government liability. Because look, there are 500 such notes which are in circulation across the country. Whenever they come to the Reserve Bank of India counter, we will exchange it. 1 year from now, 10 years from now, 25 years from now. The guarantee of the central government has remained, and in discharge of its obligations as a guarantor, 5 years from now of that notional date, we will accept the note because the guarantee is alive. The guarantee has a corresponding duty. If you go to a writ court or you file a suit, the government of India will be duty bound to honor that commitment. So please, my lords, it's a distinct concept. Legal tender is in inter partes, all inter partes transactions, whether or not involving the central government. It may be private parties, it may be a private party and a state government, it may be private parties and the central government. All those where it is exchanged, it shall be legal tender, or as your lordship says, the medium of exchange, etc. of the specified. But guarantee conceptually is completely different. So to answer the question, in my respectful understanding, these are distinct concepts and there is no automatic extinguishment. I think Justice Gawai's question to me was that, is there an automatic extinguishment? The answer according to me is no. Now I'll give you another reason why. It cannot be that a subordinate action or an administrative and executive action robs a legislative guarantee furnished or assured under 26(1). That's another way of looking at it. It ought not to be. 26(1) is a statutory guarantee in terms of a parliamentary statute. That cannot be diminished by an executive action, howsoever wholesome it might be. It has to, as a matter of law, be extinguished by parliament or by the legislature.
That is why the 2017 Act was.
Absolutely. So that's the point. And that's exactly the point. Happened instantly, but happened eventually on the 31st of December 2016, not because of the notification, but because of the ordinance. So I come to, I hope I've made myself clear. I'm attempting to answer Justice Nazeer's question. What happened on 8th November? By virtue of the notification, legal tender, we're going back to 26(1). Every banknote shall be legal tender. That stopped. It stopped being legal tender under 26(1) immediately.
For my question,
Yes, sir.
one answer came from the sister. That is, if there was automatic extinguishment of guarantee, where is the necessity for an act, was the answer to my question which came from the bench. But then another question is, in 1946, Ordinance 3 of 1946, there was the first demonetization which happened through statute. So once a statute has come, there is no necessity for a second action, correct?
It depends on the terms of the statute, but I fully agree with you. I also said that.
Then why did section 26 capital A was introduced by an act of 62 of 1956, reiterating that why is there a second statute?
26(a).
Yes, 26 capital A.
Notwithstanding anything.
Therefore,
26,
you
no
can't
banknote.
ignore you can't ignore the fundamental concept of this liability of the guarantor being coextensive with that of the principal debtor cannot be, that you can't go against the most fundamental principle. You
All right,
have
so-
other arguments,
No,
but then
No, let me suggest, sorry.
Let me intervene. I didn't mean what my learned senior brother meant. The reason why 26A came was the earlier demonetization were by an act of parliament. That is why they say notwithstanding anything contained in section 26, no bank note etc. came. And in the earlier two demonetizations, the extinguishment of liability was in the parliamentary act itself. Unlike here where it is by an executive order. Therefore, 26A by way of precaution it was added.
then where is the second act? Why should there be a second act?
I'll tell you, Lordship,
Here,
let me just explain it simply.
Not in the executive
Yeah,
order.
so let me explain it as even more simply if I can. First, I ask myself, can Parliament, in exercise of its plenary jurisdiction as a theoretical issue, pass a law extinguishing both legal tender as well as central government guarantee? Only parliamentary statute or ordinance? My answer is yes, it can do that. All right, subject to whatever constitutional safeguards, etc. there are.
No problem.
Correct. So first, Parliament can do that. One. Number two, employing the expression which your lordships have used in internet mobile and which the Attorney General quotes, RBI is a creature created with a mandate to get liberated even from its creator. Now what that meant is, sorry.
Correct. Therefore, the judgment should get liberated from the creator now.
Yes. So whatever. So you have plenary power, which we all agree, at least tentatively, that Parliament can certainly do it. The question is, can the executive do it? The answer is yes. The executive can do it following the discipline and rigor under 26. That's the second level. Then we come to a third level. What can the executive do? Sorry. The executive override Parliament through notification.
So, Diwan,
Yes.
even under the 1970 Act, 78 Act,
Yeah.
the provision that was made that on an expiry from such and such date, all high denomination banknotes shall, notwithstanding anything contained in section 26 of the Reserve Bank of India, so and so,
Correct.
cease to be a legal tender.
Yeah.
There is no specific provision as has been made under the now 1917 Act. So if your argument is to be accepted, then those notes of 10,000, 5,000 denomination still exist. And if somebody has, then the government is guaranteed to pay it.
Yes.
If the argument is to be accepted, it will have to stay to that.
No, maybe we'll see that. I'll examine that and I'll come back to your lordships on that. But now, fortunately for me, not only does the union government say it on affidavit, but
in any case, what turns on it?
so we'll come to that in a bit. We'll come to that. But now let us see what the ordinance says. Let's see what the ordinance says now. So I am requesting your lordships now to take the ordinance. Please, that's at page 38 of my compilation 1. We are looking at the ordinance, not the act. The act is in same terms, but the ordinance came first. This particular set of directions given by RBI as confined to people who took currency abroad, but it is silent on people who left currency here. And I think, in my respectful submission, I don't know, I suppose jet-setting lawyers can go up and down the country and buy a ticket immediately and come back, etc. But I think the government of India adopted a very reasonable stand initially when they kept it open because they were respectful of rights. And to answer Justice Gawai's question, I think the presumption has to be that citizens who come and who have genuine cases, if they are able to explain it on the strength of an affidavit, is bona fide and on the basis of passports, etc., and there is no history of them being a history cheater or something, should be presumed not to be a terrorist, someone engaging in trafficking or counterfeiting. I mean, these are amounts which are a huge amount for the individual himself or herself. And to be just, so therefore, I come to the point that this exclusion in the RBI, so that's the next route which your lordship can follow. Clarify the notification of 30th of December Another route can be clarify that this RBI notification applies only to situations where currency was taken out and brought in. For those who say that the money remained over here, they must be given an opportunity. Otherwise, it means that there's a huge class of people. Now I'm in terms of the notification. It's a huge class of people unfairly excluded from the process. And it is no answer to say that you had for 50 days to come back to India. It's no answer to say. This is a very patronizing attitude on the part of the RBI that, look, I will issue a notice. And how could I, the submission made was hope of extension. There was no hope of extension. My rights were not founded on a hope of extension. They were founded on the basis that the Prime Minister and the statutory notification issued by the Ministry of Finance on the 8th of November both said that there will be avenues available to you even after 30th of December. And it came through. So why exclude me is the question I asked myself. Such exclusion is completely heartless and completely arbitrary is my respectful submission. Now please go to section 4. Now I'll wind up on section 4 and then a few other small points. Section 4 at page 40, clause 4 of the article, page 40. So does your duty to cover, your duty to have an appropriate notification, does it not extend to situations like us? That's the question. Power coupled with duty, 4.1. Notwithstanding anything contained in section 3, the following persons holding specified banknotes on or before 8th of November 2016 shall be entitled to tender within the grace period with such declarations or statements at such offices of the Reserve Bank or in such other manner as may be specified by it, namely, please go to Roman 2, such class of persons and for such reasons as may be specified by notification by the central government. So my first submission is excluding a category of NRIs who had money in India is arbitrary in our respectful submission. It is so manifestly arbitrary that it is under-inclusive, going under the traditional classification test. NRIs form a single class. Some carried the money out, some left the money here. Both have to be treated similarly. You cannot create an artificial barrier or an artificial subclass and extend the grace period only to people who carried money abroad and didn't and declared it in the customs, etc. when they came back. So it is under-inclusive, is my respectful submission under the classical test. It's manifestly arbitrary to exclude us as a whole category. Apart from the other categories mentioned by Justice Gawai, there's so many people who may be medically unable. There is another person over here, for example, whom Mr. Prashant Bhushan represented, Sarla Srivastava. Her husband had died in 2016. And in 2017, January or February, what was it? January, when she was cleaning up some trunk, or what is the correct expression? Steel trunk. She was cleaning up a steel trunk. There was money which was discovered, 1,79,000 is a lot of money for her. Her husband had died. Now, this is in January. And she wrote to the Prime Minister and said, please help me out, which was referred to here and there. And then now she's in court. And this, therefore, is a very, so that exclusion for genuine and hard cases, I would respectfully submit, puts an even higher duty on the government to be sensitive to such cases and to create an appropriate subsection. So my submission is, central government is wanting in its duty. The second submission is that subsection 2 is in any case a standalone provision. Your lordships have said that we prima facie, I mean at the opening, not after, before hearing them, felt that look, this is something power coupled with duty which even the RBI can exercise, but RBI has also acted in a manner which is incorrect. Now I'm done with this section 4 part also. Now 2-3 small points remain. The first is on judicial review. And I want, so I'll just sum it up. There appears to us to be a yawning gap of persons not covered, a huge gap. I've indicated 2 or 3 situations. There ought to be at least some broad categories to capture genuine cases such as this. So one part of the argument is yawning gap. The second part of the argument is, in any case, grace period has been extended to all NRIs till 30th June. Why deny it to me? Just because I kept my money here. That's the second broad argument. Now I'm on judicial review. Judicial review, your lordships know, have been held to be part of our basic structure of our constitution. There's a whole bunch of series of Supreme Court constitution bench judgments on this point. Now, what's the issue over here? Judicial review is being disabled at two levels, and I would respectfully submit, you please, your lordships will have the time to reflect on it and to decide what the correct course of action is. Just take a hypothetical situation. I'm not saying this is the situation here. Supposing under 26(2), the government had handed over minutes and agenda notes and notice and recommendation. And in this hypothetical situation, supposing all four of them were blank sheets of paper, what would the court say? The court, does it have a, the question I'm asking myself is, the part of judicial review and your lordship's oversight, judicial review oversight, limited as it is, surely extends to an informed decision on parts like this. And an informed decision can be arrived at on an issue like this in exercise of your power of judicial review. The request is, don't diminish the court by allowing them to keep these documents, which are not some high security documents. They are administrative documents. They must be, they ought to be disclosed. They ought to be perused by the court. Why? Because it reduces and diminishes the power of judicial review. So please consider that facet as well. And I would be greatly obliged. I think the part on guardrails and to lay down defining parameters is an aspect which survives apart from individual cases like mine, where there may be 1,62,000. I believe it's an imperative. We are way past this stage where you can have some diktat issued by some ruler or something like that and say that what I say is final. No, it is subject to being reasonable, fair and just, whether it is statutory or otherwise under our constitutional scheme. So how is this power of judicial review to be exercised unless these basic documents are made available to the court? So I would respectfully implore the court that please also, as far as guardrails are concerned, and what are the parameters, whatever appropriate expression your lordship would like to use, please use it.